Thank you very much, Mr. Chairman, and thanks to all of you for being here. It's important to remember that when Congress proposed this amendment in 1972, it didn't happen in a vacuum. When Congress went to propose it, it didn't have the votes that it needed. It added the 7-year limitation in order to secure the consensus necessary to achieve a 2/3 supermajority vote in both houses. In other words, there were members of Congress needed to vote for it who weren't willing to vote for it without that provision. So that's how they achieved the bargain. And we can't just ignore that. That shouldn't be ignored. You can't ignore it without doing violence to the process articulated in Article 5 of the Constitution for how to amend it. But it's important anytime we amend the Constitution to make sure that we understand what the language means. We've seen through other amendments, one of many examples would be the 14th Amendment. You can't always anticipate at the outset when you adopt something like this what ramifications it might have, and that's one of the many reasons it's important to get this right. All sorts of things have changed since 1972, and that's yet another prudential reason why it makes sense to put limitations in there. But to be very clear, there is a remedy for what you're talking about. When something expires, it's not like it can't ever be brought up again. It's just that it becomes a different proposal. That proposal has a shelf life. That shelf life has now passed. It has expired. Congress could propose another equal rights amendment. It has yet to do so, and that matters. It matters in a way that's been recognized by the courts. The U.S. District Court for the District of Columbia ruled against the position that this can be extended. And the U.S. Court of Appeals for the D.C. Circuit today affirmed that ruling. So this argument has lost at the District Court. It has lost at the Court of Appeals. If it were to come before the United States Supreme Court, it will lose there too. And so that really is a significant thing. There are some policy considerations that also need to be taken into account. In the 1970s, my dad wrote a book. It was called The Lawyer Looks at the Equal Rights Amendment. And he asked a number of questions about the legislation. And one of the questions he asked that he identified as the most important question relates to what standard of review would be applied if the Equal Rights Amendment were to become law of the land. He asked, for example, is it going to be rational basis? Is it going to be strict scrutiny? Is it going to be intermediate scrutiny? Or what's it going to be? Or is it going to be a complete prohibition or a complete prohibition with qualifications? Ms. Braceras, does the text of the 1972 ERA make clear what standard of review courts would apply?
It does not, but the advocates of the ERA hope and will argue that it requires strict scrutiny.
Okay, and under strict scrutiny, if it were to apply, how would that be different? Because currently, something like this, where there is a government-imposed distinction, a differentiation on the basis of sex, it is not strict scrutiny that applies. It's a form of intermediate scrutiny. Tell us why that matters. Why do you think that matters? What's the difference between switching from intermediate scrutiny to strict scrutiny?
So strict scrutiny is the standard that courts use to analyze policies that deal with race, and it's the right standard to use with race because in the racial context, separate is unequal. That is not true in the context of sex. Separate is not always unequal for women and men when it comes to issues of privacy or places where biological differences matter, such as sports. And so sex should not be treated the same as race under the Constitution. Our current intermediate scrutiny standard leaves space for courts to take into consideration biological differences where they matter. And in all other cases...
strict scrutiny doesn't accommodate that in the same way.
No, it does not.
So what might this do for sex-segregated prisons, prisons for women? What might this do for government-sponsored, government-funded, and operated shelters for abused women, for example, or public restrooms, locker rooms, athletic facilities, athletic competitions? What might strict scrutiny do to every one of those?
So in the racial context, courts have been very clear that prisons cannot separate inmates on the basis of race, even where doing so would prevent certain gang violence in the prison, and that's the right standard. They should not be able to separate inmates on the basis of race. If you applied that same standard to men and women, that would mean that prisons could never, they would have to have co-ed prisons. You could never separate inmates on the basis of sex, and male and female prisoners would have to be housed together.
So protections in law, state and federal, as they now exist, protections put in place for women reflecting biological differences between men and women, based on differences between men and women, would be at stake. They would be jeopardized. They would be threatened, and in many cases, undone through judicial order.
That's correct.
Thank you, Mr. Chairman.
Thank you, Senator Lee. Senator Blumenthal.
Thanks, Mr. Chairman.